Now, Benue State Governor Hyacinth Alia and Zamfara State Governor Dauda Lawal failed to appear before the House of Representatives Committee on Public Petitions, despite being summoned over allegations of unlawful suspension of lawmakers in their states. The civil society group Guardians of Rule of Law and Democracy filed the petition on March 27, 2025, claiming the governors orchestrated these suspensions, which disrupted legislative functions in both states. The group urged the National Assembly to invoke Section 11, subsection 4 of the 1999 Constitution, potentially taking over the legislative duties of the affected assemblies. In Zamfara, the assembly suspended 10 members after a disputed impeachment of the speaker, while in Benue, 13 lawmakers were suspended for opposing the removal of state's chief judge. The petitioners argue that suspensions longer than 14 days are unconstitutional. Now, joining us on Newsday to discuss the summon of Benue and Zamfara state governors by the National Assembly is human rights lawyer and former president of the Committee for the Defense of Human Rights, Malachy Ugwumadu. Good to have you on the show. Thank you for joining us.
Good afternoon. I'm delighted to be here.
Now, let's start with your reaction to this summon by the National Assembly for the, sent to the governors of Zamfara and what's other states now, talking about, bringing them to the National Assembly to account for their actions. Do you see it as a way to give or to make the governors accountable? We've seen different reactions to it, especially from the senior advocate of Nigeria, Femi Falana, saying that they do not have the constitutional powers to summon these governors. What's your take on this?
Well, my concern really is the fact that in the National Assembly, I'm not too sure about the 10th Assembly, but in the previous assemblies, you used to have a grand swell of seasoned lawyers, some of whom senior advocates of Nigeria. And to find that the National Assembly, which is an arm of government, has now condescended to such a level where their roles, as specified under the Constitution, is no longer carried out along the line of the law. It's becoming a bit concerning to some of us. What the law says, precisely under Section 88 of the Constitution, is that the National Assembly shall have the right to oversight every agency of government, every authority, to whom that same National Assembly had made appropriations to. In other words, if you have received from the National Assembly appropriations to your department, agencies or ministries, or heads of ministerial departments of the government, and so on and so forth, such a person shall be subject to, investigation, oversights, and so on and so forth. But we practice constitutional democracy founded on federalism. That federalism recognizes the juxtaposition of state powers at different tiers of government, at least at two levels of government, the federal government and the state government, presupposes some measure of autonomy, some measure of independence and interrelationship. What that presupposes is that the tiers of government in reference or under reference are independent of each other. There is no way the National Assembly can extend an invitation to the governor of a state to come and account to it with respect to anything, when in fact there is a state House of Assembly that is properly constituted to discharge the functions of those oversights within the state. Granted that as a nation, you have as one of the fundamental objectives and directive principles of state policy under Section 15:5, by which the state declares that it shall abolish corruption and all forms of abuse of power. Now, once that is the case, once that is the situation, what can only happen is that the government, as a government, can promote policies, give directives, promote directions that denounces and condemns all forms of corruption, but not to extend the invitation to democratically elected governors of the federating nations. It offends the principle of federalism. It is against Section 88 of the Constitution, and it cannot fly in the face of the constitutional democracy that we practice. So I am one of them. I haven't listened to the views of many people, but this is my immediate reaction that you have just sought to hear.
Well said, and very well put, Mr. Ugwumadu. But what constitutional safeguards prevent potential abuse of legislative summons power? Well,
again, I struggle to hear you, but I think your question revolves around
I'll repeat the question.
Constitutional mechanisms.
I'll repeat it one more time, and I just can you hear me, please?
Please.
Okay, thank you. What constitutional what constitutional safeguards prevent potential abuse of legislative summons power?
Okay. Now, for me, I had referenced the fundamental objectives and directive principle of state policy, particularly Section 15, subsection 5, that in general terms condemns corruption and abuse of power, which is one of the directives of state principle. In other words, one of those aspirations that we have as a nation, one of those heights that we, that we hope to attain. Besides, the legislative arms of government, and I use my words advisedly, both at the national level and the state, the federating units, have inbuilt constitutional mechanisms by which they are empowered, either through legislative oversight or even through appropriation and investigation, to go deep into the activities of the executive. That way, there are mechanisms inbuilt, constitutionally secured, by which the legislative arm of government is supposed, ideally, to deal with issues of corruption and abuse of offices, particularly from the executive. The big question is, are they functional in the discharge of this responsibility? Unfortunately, we have seen that most state legislatures or legislative houses have come short of that responsibility, and it is a free ride for the executive. Now, where such occurs, we have, as a state, as a political entity, the emergence of civil society groups, many of which dedicated to the monitoring, for instance, of the budgeting processes and the implementation of those budgets. I, for one, I think in 2009, thereabout, 2009, 2010, approached the Federal High Court in this country. What were the reliefs? For the court, through an ordinatory summons, for the court to determine whether the government is at liberty to implement the budgets, in half measures. Because in our view, you call it budget, but those are appropriation laws. Therefore, the question was, can a government choose part of the law to implement and the other not to implement? Such are the ways by which the civil society, by which the populace can assist constituted authorities to oversight, to guarantee and ensure that this whole corruption malice that has become the behemoth in our society is not only moderated, but checked to a large extent. And I think that the greater responsibility lies in the quality and content of the people who we elect into the legislature. People who we know that their future does not lie in what the executive or the governor of the state says. People who realizes that for democracy to thrive, you must have a very solid legislative house, a house that can stand on its own and point out the transgressions of the executive and be able to do one or two things to moderate the excesses of the executive. Where that does not happen, the tendency is that the executive assumes all the power, and you will soon come to the realization that power corrupts, and absolute power corrupts absolutely. And that is largely what we see in most states of the Federation, even up to the National Assembly, but I dare say it is much better at the National Assembly than in the federating units. Most of the legislative houses are now seen as appendages or extension of the executive, which is not a very good development in our polity.
Very well said, Mr. Ugwumadu. Now, how do you interpret Section 82 of the 1999 Constitution as regards this case? And also, what role do you think the judiciary should play in determining the limits of the National Assembly's powers?
So, my take would be that the two states affected is a political entity that exists in the same way that the National Assembly exists, which is why we say federating units. They are at different tiers of government. So whereas we advocate, it becomes evidently clear that there are certain things untoward in the invitation extended to the executive governors of those respective states. It will take the attorney generals of those respective states to politely communicate and point out the law quite clearly to the leadership of the National Assembly if they were in doubt or not too sure of where the limits of their powers lie. Where they choose to remain recalcitrant, then they don't have any other option other than to contest the propriety of that invitation, of that exercise of power. For me, I don't know where that power is coming from. So, and the courts will very easily, in my view, come to the proper interpretation of the Constitution to determine the issues against the backdrop of the law as we have articulated. But more importantly, to emphasize the point that we practice constitutional democracy founded on federalism. And I have tried to discuss federalism as limited as I can to underscore the point that you cannot jump from the federal government right into the federating units and begin to manipulate and exercise the same powers that you don't have. Quite frankly, in my view, they don't have such power to make such an invitation, not to the executive governor of a federating unit. So the judiciary is there. The law under Section 6, Subsection 6, is that where there is a dispute between the arms of government, or between the states and the federal government, or between individuals, as the case may be, the courts are there to resolve it. In fact, given the sensitivity of such a course of action as is brewing at the moment, namely that the Benue and the Zamfara states may have with the federal government, if you interpret the National Assembly as part of the federal government, then that can easily invoke the jurisdiction of the Supreme Court of Nigeria to entertain the matter as a court of first instance. Where that happens, we will all be better for it in understanding what the position of the law is and in taking advantage of such a concrete legal development to understand the limits of the power. And that's the beauty of constitutional democracy. It's about delineation of the powers. It's about understanding the limits of the powers that there are in the Constitution.
We lost connection with a human rights lawyer, that's Malachy Ugwumadu, but we'd like to thank him for his time and insight here on Newsday.